Everyone to part one of our two-part 2021 employment law year in review. Tonight, I'm Laura Chapman, one of the partners at Casey, and I'm joined by my colleagues Simon Lapthorne, David France, Malin Chen, and Michelle Hall-Collins. And we're going to take you through quite a canter of topics that have come up during this year. And I think if we thought 2020 was quite the year to have had, 2021 is probably even more so. So we do have a bit of a slant towards some of our COVID topics. Can I ask that because we have a lot to cover, if you have questions, please can you put them in the chat function for this evening. We will address some of those at the end to the extent we have time to, but if you can leave your details in the question, we'll also attempt to get back to you if we're not able to answer it during the session. We'll also be keeping strictly to time, so each of the topics you can see on the slide there, we'll have about 10 minutes to speak to, and obviously you'll be muted during the period of time. So as I say, if you've got questions or comments, please just leave them in the chat session. So with that, I will hand over to my fellow partner Simon, who will be taking us through working in a COVID environment, which I'm sure we're all fairly used to now, but there's some useful information he's got to share with us. So Simon, over to you.
Thank you, Laura, and good evening, everyone. I'm going to start by looking at the topic of working in a COVID environment, which I think everyone will now be familiar with. And I'm going to briefly review the current alert level system before looking ahead to the COVID-19 protection framework that is coming into force shortly, with a particular focus obviously on employment and work issues. Starting off with on the first slide with the alert levels. As you all know, we went into alert level 4 lockdown on the 17th of August 2021. And alert level 4 is where there is sustained and intensive community transmission of the disease, and it's likely that the disease is not contained. And from an employment perspective, the measures that were applied, and those measures could be applied locally or nationally under level 4, are that you're required to work from home, and businesses must close except for essential businesses, so supermarkets, pharmacies, petrol stations, and lifeline utilities. Level 3, so level 3 is the restrict level. And again, you'll all know that we've been in level 3 in Auckland since the 21st of September. Generally, level 3 is where there are multiple cases of community transmission or multiple active clusters in multiple regions, and there's a medium risk of community transmission. Under level 3, you're required to work from home if you can, and only people who cannot work from home should return to businesses that can safely open. And you're required to keep a 1 metre distance in the workplace where it's practical. Customers are only allowed inside specific businesses, such as supermarkets, banks, etc. And other businesses can open if they can trade in a contactless way. And I think people generally understood the 4 alert levels, but the government then introduced a number of additional steps for level 3, which I think have kind of complicated the picture. So under step 1, that provides for outdoor catch-ups, which again, I think people will be familiar with. And there's a limit of 10 people from no more than 2 households, and you're required to wear a mask and socially distance. Under step 1 of level 3, there are also provisions in respect of early childhood education and other provisions in respect of recreation to allow people to move around the city more freely and undertake leisure pursuits. Under step 2, which we have recently moved to, retail can open. You're required to keep 2 metres apart, wear face coverings, and public facilities can open. Outdoor gatherings have also been expanded to 25 people, and the government's removed the 2 household restriction for picnics, and outdoor organised exercise classes are allowed. Under step 3, which we may not actually get to, but hospitality can reopen with a limit of 50 people. And again, event facilities can also open with a 50-person limit. I think significantly for close contact businesses such as hairdressers, they're they'll be able to reopen, which I think will be a relief for many of us. But workers are required in those businesses to wear face coverings. Other parts of the country that were at level 3 have moved down to level 2, including the Waikato, which I think is moving to level 2 from 11:59 tonight. And again, you'll know that this is where there could be limited community transmission. Under level 2, you can return to the workplace, but alternative ways of working are still encouraged, and businesses can open with additional health measures in place. Again, social distancing is required, so you're required to keep 1 metre apart in office buildings and factories. And under level 2, you have to wear face coverings if you work in certain occupations, so drivers, working in close contact businesses, if you're in public facing roles at hospitality, etc. And then finally, in kind of this rapid recap of the alert levels as we currently understand them, alert level 1 is where the disease is contained in New Zealand, and it seems an age ago that we were at this level. So at level 1, COVID's uncontrolled overseas, and there could be sporadic imported cases. But under level 1, significantly, all businesses and workplaces can open. But I think it's unlikely we're going to see this level again. And if we move on to the next slide, that's largely because of the government's plans to move to the COVID-19 protection framework. So the government's announced that the next stage of the COVID response plan is intended to provide a pathway out of lockdown and to give vaccinated New Zealanders more freedom. And Laura's going to be discussing a little bit more about vaccination in a moment. But originally the government stated that once 90% of New Zealanders are vaccinated, we would move to this plan. And we understand that Auckland could hit the 90% double vaccination rate by the 29th of November. But I think there were certainly suggestions from the government yesterday in the Prime Minister's press conference that it's actually considering moving to the new framework sooner. Obviously, there'll be an announcement about the border tomorrow, and potentially, I think, an announcement about moving to the framework as early as next week. Under the traffic light system, and green is where there are some COVID cases in the community. Generally, community transmission is limited and hospitalisations are at a manageable level. And one of the key features under the protection framework is that generally record keeping and scanning are going to be required. At green, face coverings are mandatory on flights. Workplaces are open, and you can go to public facilities, shops, specified outdoor community events, and the regional boundary restrictions don't apply. There are no limits on numbers if vaccination certificates are used, but for close contact businesses, again, the requirement remains to wear face coverings. At orange, there's increasing community transmission. At orange, again, public facilities are open with capacity limits based on 1 metre distancing. Workplaces and retail are open, again, with capacity limits and 1 metre social distancing, and regional boundary restrictions won't apply. Under orange, there are no limits on numbers of vaccination certificates are used in certain kind of areas or industries, but there are limits where there's no proof of vaccine. And then finally at red, and it's red that we're likely to migrate to, action is still deemed to be necessary to protect at-risk people in the health system. Again, record keeping and scanning are still required, and face coverings are mandatory on flights, public transport, etc. There are limits, capacity limits for retail. Workplaces are open, but working from home is still encouraged, and regional boundary restrictions may apply. Again, there will be restrictions, so the restrictions will apply even if vaccination certificates are used. But the following places can open with up to 100 people based on 1 metre physical distancing, and that's hospitality, gatherings such as places of worship or marae, weddings, civil union ceremonies, etc., events and gyms. And close contact businesses will be able to open with other requirements, so they'll have to apply public health requirements. So those are the public health requirements we're familiar with. And if a business, organisation or service doesn't request proof of vaccine, then again, restrictions will apply. Finally, I'm just going to finish off by looking briefly at some factors that are relevant to working in the COVID environment. So clearly our ways of working have changed in the past 2 years. And I think there are a number of considerations that employers now need to take into account when working in the COVID environment. Obviously, we've seen a significant impact on business as usual, what we knew to be business as usual. And I think companies and employers have had to adapt. Many have had to change the way they operate and have enhanced their online presence. And I'm sure you would have seen in your own areas, businesses that perhaps weren't set up when we were in lockdown last year have obviously adapted, made the transition, and have set up the ability to kind of trade or sell online and to deliver their products, etc. I think another key consideration of working in the COVID environment relates to information privacy, information security and privacy. So for most businesses, when you consider flexible working, I think that involves working remotely. And this requires a plan to ensure that privacy obligations can continue to be met. And I think if possible, when working from home, you need to ensure that your living space and workplace can be kept separate. I think it's also important to have a space where you can discuss matters with client confidentiality. I think it's something that rings true for me personally, and my wife's also an employment lawyer. Obviously, we're dealing with kind of confidential or sensitive confidential information. Files and documents should be kept secure physically and electronically. Documents containing personal information also shouldn't be thrown into the rubbish or recycling, and should be shredded before being disposed of. So we would suggest that you keep separate waste paper box for confidential information that you can shred when you're able to go back into the office. Cybersecurity is also a consideration. So I think most businesses have probably already implemented security measures, including antivirus software and passwords. And some simple measures include, never leaving your computer logged on and ensuring that you back up regularly. From a health and safety perspective, as you know, employers have a duty to take steps to eliminate risks to health and safety as far as reasonably practicable. And if it's not possible to eliminate the risks, to take steps to minimise risks. Home is considered a workplace, and WorkSafe has published guidance on some of the steps you should be taking as employers. So some of the factors WorkSafe highlight are workstation, so helping employees identify somewhere where they can comfortably work from home, taking into consideration posture, ergonomics, etc.
I think on the health and safety grounds, we might, that's probably a good segue into looking at some of the vaccination considerations that we have around the workforce. Before I do, very quickly, there was a question in the Q&A function. And in fact, I didn't realise, apologies, the chat function has been disabled. So if you have questions, please put them in the Q&A function with your details, and we can attempt to answer those. So if we go on to the next slide, what I'm going to talk to you about is vaccinations in the workplace, and I appreciate this is a rather encompassing topic, and there's only so much that we will be able to speak about, but I wanted to give you a bit of an overview about where we're looking at these vaccination mandates coming in, what the background is to some of those vaccination mandates, and then what we need to think about going forward in relation to those. And this links really strongly back to what Simon was explaining in relation to his traffic light system, or the government's traffic light system that's about to come in. So if we go on to the next slide, there's now 4 main bases of having vaccination mandates in the workplace. So it started out very much with vaccination orders. So under public health orders from the government, they were mandating vaccinations first for people in managed isolation quarantine facilities, and then border workers. And from there, that's been expanded. And more recently, we now have prisons, health workers, and education that has come in. So you will have heard, I'm sure, a lot of people have had discussions either with their children's teachers and or their health professionals and others about vaccine mandates coming in. And all of those are by virtue of government orders so far. Now, those I won't speak too much about because I think most people who are subject to the order, or most employers who are, will be working through those or will have worked through those already. There's also workplaces who were pretty quick in putting policies in place prior to the COVID-19 protection framework coming in. So again, that will include anyone who's finalising their policies essentially now and during this month, and who has a policy or a requirement in place essentially for their workers to be vaccinated or to carry out, continue carrying out work of certain kinds. The third one is where, and this comes back to what Simon was talking about. So what the government has said is that workplaces where customers have to show COVID-19 vaccination certificates will require their workers to be vaccinated. Now, we don't have a whole lot of information on this yet in concrete terms. There is some consultation going on by the government and MB in particular, looking at how they may put this framework together. And as we know, the government has indicated that they will provide both a framework for a risk assessment, so how you will carry out a risk assessment to determine whether or not your worker should be vaccinated to continue to carry out work of a certain kind, and also more detail on how this framework will work to require employees to be vaccinated. And then the fourth category is employers who are thinking about putting a mandate in place, but they haven't done that yet, and they're not covered by the rules around that traffic light system. So when people have to show COVID-19 vaccination certificates, or where there's orders already in place, and that will be covered by this new risk assessment framework that we think will be coming out. So if we go to the next slide. So what we're seeing is, as I mentioned, the government is going to introduce this risk assessment process. Now, I can't say too much about the risk assessment because it is the key to each policy and or mandate that is being put in place. Now, it's not entirely clear as yet the link between having a mandated requirement, i.e. you are in a workplace where customers need to show vaccination certificates, and carrying out your risk assessment. But I think it would be prudent to actually carry out that risk assessment in any event, because I think there will be, whatever that risk assessment framework looks like, there will be difficulties in applying it in certain businesses. So for example, some of the things I've touched on there that the government's considering around that risk assessment is looking at the work environment. So looking at ventilation, is it indoors, is it outdoors, is it partially both? So an environment where you have open doors, for example. Are you able to practice physical distancing? So if you've got an office and you each have your own offices, you'll obviously be able to physically distance, will be able to practice physical distancing much easier than if you sit in cubicles or you sit in a row of desks together. Also, do you have interaction with the public? And the way in which that has been reflected before is actually people who are easy to identify. And interestingly, what that does is mix some public health considerations, so looking at who is able to be traced and identified, and then an outbreak might be contained, and actually your workplace health and safety considerations, which look more at what are the risks directly to your people. Now, the last one is also the amount of contact with others more generally. So if you're sitting, again, my example of sitting side by side, or where we're talking about close contact businesses that will be covered by the vaccination certificate mandate. So if you're a hairdresser, etc., you have quite a lot of contact with other people. And what I've also put in there is you have to, as part of your risk assessment, not just think about what is the risk to your employees, but also think about what other alternative controls might be available. So for example, if your people can generally work from home, and we know that people can or can't at this point in time, because particularly in Auckland, where we've spent quite a long time working from our homes, is that going to be sufficient to allow your workers to continue without being vaccinated? Or is it the case that really at some point they're going to need to come into the office, and at that point they will be exposed to more risk? So it's all sorts of controls and different things you have to be looking at, and that is quite a complex process. Now, WorkSafe currently has some questions on its website about how you can determine whether or not work of certain kind requires vaccination. And it's questions like, again, similar to what I've said, how many people does it come into contact with? But interestingly, in that set of questions, there's a question around, will your employee be more likely to be exposed to COVID inside the workplace than outside the workplace? And that's a very difficult question for a lot of employers. I think it works where you are in education, you're in health, there's an obvious risk, or you've got a high density business where you have a lot of people coming in and out. That's more difficult to answer that question in an office environment. And so I think that might be one of the things they do look at changing once we get this new framework. Now we're expecting the framework at some point between 27th of November and the 30th of November. So we are to some extent crystal ball gazing at the moment. So if we go into our next slide. So this is looking at other considerations. So one of the things to highlight is, and I'm sure many of you will come across this already, but if you are collecting information on vaccination status, that is obviously personal information, and it's relatively sensitive personal information because it's actually medical information. Now you can collect that information, but you must tell your employees that it's voluntary and you have to have a good reason to collect it. So you can't collect it if it's not necessary. However, if you're looking at carrying out a risk assessment in your workplace, whether or not your employees are vaccinated is likely to be one of the factors to consider in relation to that. The second thing I wanted to highlight is that in the government's announcement, what they have indicated is that employers will be required to give paid time off in order to enable their employees to have a vaccination. Now, usually that's going to mean a kind of a vaccination appointment. But we have seen instances where there's kind of a flow-on effect. So particularly in a business which requires some sort of stand down or a period of time after the vaccination, for which, for example, if you're operating machinery or otherwise, that they don't want you to operate that machinery, particularly if you could have side effects, etc., from the vaccination. And often that's a kind of 24-hour period, or any time from half an hour to 24 hours. They've also indicated that if you have to terminate an employee because they don't meet the vaccination requirement, that they'll be required to have a paid 4-week notice period, or their notice period in their employment agreement if that is longer. But generally that 4-week, and again, we're not sure how that is going to operate as yet. Don't forget that in any of these processes, it's like any other employment process that you undertake, is that you continue to have your duty of good faith and your other employment obligations. So the employee's employment contract will continue to apply. Any other policies and procedures that you have that might touch on this process will also continue to apply. And the last question was really, we see a lot of questions around, or issues around liability for adverse effects from the vaccination, and or a lot of employers struggling with trying to provide medical information. The first thing is, for medical information, employers are entitled to rely on publicly available medical information from reputable sources. So again, Ministry of Health, WorkSafe, and the government's COVID-19 websites are good sources of information for that you can rely on. In terms of liability, ACC has some good information on what it will and won't cover as a result of the vaccination. And insurance companies have come out to talk about their policies in relation to the fact that generally insurance policies won't be affected by having a COVID vaccination, so private medical insurance might be available. So as I said, that's a very, very quick canter through some of the key issues that we're seeing and have seen this year in relation to COVID-19 vaccinations. And to continue with our pervading theme, I will hand over to David to talk to us about a case law update on COVID-19. Thanks, David.
Thank you, Laura. So I'm going to progress with the theme around COVID-19 and developments over the last year, but from a case law perspective. There's been a number of cases before the courts and the authority which have had a COVID-19 theme to them, and there are still a number of cases to be heard. But I'm going to look at two cases in particular which should have some practical relevance to HR practitioners and employers in particular. One relates to an employee who claimed unjustified dismissal after they didn't get vaccinated and were terminated as a result. The second one concerns the obligations of employers to employees in circumstances where during lockdown they directed their employees to stay at home rather than come to work. So looking at the first case, which is an authority case, GF and NZ Customs Service, that scenario involved an employee who was a border protection officer. And as many will recall, about a year ago, the government started to talk about the importance of our workers at the border being identified and being vaccinated, and identified that group in particular as a priority group when the vaccinations became available in New Zealand. And from around that time, the NZ Customs started to commence a course, if you like, focusing on encouraging its workers to get vaccinated as soon as they possibly could. The employee or the claimant in question in this case obviously didn't get vaccinated and ultimately was terminated, the employee's employment was terminated. The termination coincided with the introduction of mandatory vaccination orders by the government for border workers. But why this case is of particular interest is that NZ Customs had already gone down a significant course in dealing with requiring employees to get vaccinated before this order came into being. So it has quite significant importance from the fact situation for not only for employers who may be covered by government mandatory orders, but also for employers who have introduced mandatory vaccination policies or are thinking of doing so, and what their obligations are towards employees, particularly those who are not getting vaccinated or haven't been vaccinated when they come to implement the policies. In this case, what was identified as key was the provision of information. So from the outset, Customs was very focused on providing information to all of its employees regarding vaccination, the importance of being vaccinated given the roles they were in, and the risks to them, to their workers if they were not vaccinated. And there was a real campaign of continuous information by NZ Customs to its employees to make sure the significance and importance of vaccination to them was clearly, there was clear education around that. It also conducted a health and safety risk assessment and engaged thoroughly with staff throughout that process to ensure staff had buy-in and input into that risk assessment. It identified who hadn't been vaccinated at various times and looked to interact directly with those individuals to see what additional information and support could be provided to individuals who hadn't been vaccinated. It arranged to meet with staff who still had not been vaccinated despite everything the Customs had endeavoured to do to promote vaccination. So met with individuals who still hadn't been vaccinated to talk through with them their concerns and reasons, to carry out a one-on-one health and safety risk assessment with those employees to assess in particular whether they could safely carry out their roles if they remained unvaccinated. They also looked very carefully at redeployment opportunities. This was the background leading into ultimately the decision to terminate the employment of this employee. The employee remained unvaccinated and was subsequently invited to a meeting to discuss that specifically and also to potentially terminate the employee's employment, and Customs followed a thorough process there. So what this case is very helpful in relation to in educating us on is providing guidance around the extent the employer has to go to if you have mandatory vaccination policies before you can get to the stage where you may choose to terminate an employee's employment. And the clear emphasis in this case is that you really need to exhaust all other options before you get to that stage. That case in particular is before the employment court, so we will see if the employment court has anything to say about that matter. I'll skip the next slide, which is a very brief slide on some interim reinstatement applications in relation to employees who were required to be vaccinated by the government and didn't do so. The outcome of those cases was that reinstatement was not reasonable or practicable because it would breach public health vaccination orders. Those cases will end up having a full hearing at some stage. The next case of particular interest concerns a company which sent its employees home during lockdown and arranged with their employees to pay them at a reduced rate, or 80% of their wages. The company was an essential service industry company, or identified as such, going by the name of Gate Gourmet, and it provided in-flight catering services for passenger aircraft. As we'll all appreciate, it was significantly impacted by the Alert Level 4 lockdown and the subsequent reduced alert levels, which had major impacts on commercial aircraft movements throughout New Zealand and internationally. And this impacted directly on the work for employees employed by Gate Gourmet. These employees were all paid a minimum wage, and what was agreed with Gate Gourmet is that the employees would be directed to go home, and they would receive 80% of their minimum wage, and would also be able to top it up with annual leave payments if they wished to do so. The employees through the union challenged this, the argument being that the employer couldn't contract out of the Minimum Wage Act, and they were entitled to be paid minimum wage for all their agreed hours, whether they were working or not. Gate Gourmet, however, had a different view and said, well, if you're at home, you're not working, and because you're not working, you're not entitled to be paid your minimum wage. It involved a significant analysis of the Minimum Wage Act, but the fundamental principles that were looked at were quite important in this case. The employment court liked the argument of Gate Gourmet, but when it went to the Court of Appeal had a completely different view. And what it determined is that minimum wage is payable for hours a worker is contracted to perform. So where you have agreed hours in your employment agreement, you are required and entitled to be paid for those hours, whether you work them or not. And in this case, because the employees were directed by their employer not to work, the employer was found not to, or the employees was found to remain entitled to receive their minimum wage during the period they were at home, primarily because it was the employer who was directing them not to work. It was not a situation where there was otherwise agreement to work reduced hours. The agreement only related to reduced pay. So the outcome of that case is that the court found that the workers were entitled to be paid for all their agreed hours under their employment agreement, regardless of how many of those hours they worked or not. Two important points that come out of it, however, is that there are exceptions, and they are that an employer can reach agreement with an employee to take leave without pay, which didn't happen here. And in that situation, the Minimum Wage Act does not apply. And likewise, what the employer could have done is reached agreement with the employees to reduce their contracted hours, in which case the Minimum Wage Act would only apply to the reduced hours they had agreed on. The case, we are still awaiting with the case from this case to see what the situation would be in circumstances where employees are required to stay at home by government direction, not by employer direction. That wasn't an issue before the court. In this instance, we may yet find the outcome of that. So that's the end of it for now of our COVID-19 legal development update. I'm going to pass you on to Malin, who is going to move direction and talk about immigration.
Thank you, David. I'm going to give an overview on some of the key immigration changes this year. So on to my first slide. One of the first significant changes in relation to residency. At the end of September this year, the government announced a new residence category called the 2021 resident visa. This is a one-off visa, and it has been described as a simplified pathway to residence that will become available for up to 165,000 migrants currently living in New Zealand. We understand this new visa was created as a response to the ongoing impact of COVID-19, and in particular, the growing backlog of residence applications that have resulted from the current restrictions. To be eligible for the new resident visa, the principal applicant must have been in New Zealand on the 29th of September this year and hold or have applied for one of the eligible work visas on or before the 29th of September. Eligible work visas include, but are not limited to, essential skills, work to residence, and this can include the talent accredited employer visa or the long-term skill shortage, as well as post-study work visas. Short-term work visa holders, such as workers on the recognised seasonal employer scheme or working holiday visas, will not be eligible. If you look at my next slide, applicants must also meet one of the following criteria of being either settled, skilled, or scarce as of the 29th of September. To be eligible under the settled criteria, you must have first arrived in New Zealand on or before the 29th of September and spent at least 75% of the last 3 years in New Zealand. To be eligible under the skilled criteria, applicants must be paid at least $27 per hour for an average of at least 30 hours per week on both the 29th of September and on the date that you apply for residence. Applicants that are paid less than $27 per hour may still be eligible for the 2021 resident visa if their occupation is considered scarce. To be eligible under the scarce criteria, an applicant must have been employed for an average of at least 30 hours per week in a role on a list of scarce occupations on both the 29th of September and also on the date that they apply for residence. Some examples of the scarce occupation lists include the long-term skill shortage and the list of jobs requiring occupational registration in the health or education sector. You can have access to all the lists on the Immigration New Zealand website. Applications for the new resident visa is going to open in 2 phases. So the first phase is starting next month on the 1st of December, and the second phase will start on the 1st of March. If you want to apply for the first phase, you need to be a work visa holder who has submitted an existing residence application, either under the skilled migrant category or under residence from work. The online form will be released on the 1st of December. However, if you are eligible for this first phase, we recommend that you start preparing your documents now. All other eligible applicants can apply from the 1st of March next year. And these will mainly include applicants who have an existing work visa, but have not yet submitted an application for residence. All applications must be submitted by the 31st of July, and work visa holders can include their partners and children in their application. The new resident visa will also be available to eligible critical workers and their families if they are in long-term roles of 6 months or longer. These workers will need to arrive in New Zealand and apply before the 31st of July next year. Applicants will still need to meet health and character requirements, as is required under the usual residence application process. Immigration New Zealand expects that the majority of the applications under the new resident visa will be processed within a year, which is much faster than the current processing time of around 26 months. Now turning to my next slide, another area of change has been in relation to this essential skills work visa. So in July this year, Immigration New Zealand made a number of temporary changes to the essential skills work visa policy to streamline the application process for employees who are extending their visas to remain in their current role. And this was done with the intention of creating more certainty for employees and businesses while the border is still closed. These changes include increasing the duration of the essential skills work visa for jobs paid below the median wage from 12 months to 24 months. The median wage has also increased from $25 to $27 per hour. Removing the requirement for employers to satisfy the labour market test, where an employee is applying for an essential skills work visa to remain in the full-time position which they currently hold. And removing the requirement for applicants to provide medical and police certificates if that information has been provided to Immigration New Zealand before. These temporary changes to essential skills are expected to apply until July next year, which is when the new accredited employer work visa scheme will come into effect. Now onto my next slide. For those that attended our immigration webinar earlier this year, we outlined the new employer assisted work visa scheme, which was supposed to come into effect this month. The new scheme was first announced in October of 2019, but the introduction of the new policy has been delayed several times because of the ongoing response to the pandemic. Just a brief recap on the new scheme. There will be a new work visa called the Accredited Employer Work Visa, which will replace 6 existing work visa categories, including essential skills and the Talent Accredited Employer Work Visa. The new work visa process will now be employer-led as opposed to migrant-led, and there's going to be 3 checks as part of the process. The first check is the employer check, whereby all employers will now be required to be accredited by Immigration New Zealand if they want to hire foreign workers. This is quite a departure from our current system, where there is no requirement for employers to be accredited if they want to hire someone on an employer-assisted work visa. The second check is called the job check. This is where pay conditions and the labour market test will come in to make sure the role that an employer wants to fill cannot be done by any New Zealand citizens or residents. The employer will be responsible for satisfying the job check. The new labour market test is going to be more region specific than the current test, with particular focus on the job shortages within different regions of New Zealand. The third and final check is the worker check, and you can only reach this stage of the application after the employer has satisfied the first 2 checks. At the final check, it will be the employee's responsibility to satisfy the general temporary visa requirements and to show that they are suitably qualified for the role offered. Now turning on to the next slide. As I noted earlier, the new work visa scheme was intended to take effect from this month, but has been delayed until the middle of next year. So here are some new dates on the slide to be mindful of. The 31st of October has already passed, but this was the last date to submit a new work to residence visa application. From the 9th of May next year, employers can start to apply for accreditation and the job check under the new work visa scheme in anticipation of it coming into effect from the 4th of July. And the 3rd of July will be the last day to submit an essential skills work visa for all applicants. Now, finally, it is important to mention that from staying on the theme of vaccination, from the 1st of November this year, non-New Zealand citizens aged 17 years and over must be fully vaccinated against COVID-19 if they want to enter New Zealand, unless they have an exemption for medical reasons. The guidance provides that the last dose of an approved course of vaccine must have been taken at least 14 days before travel, and travellers who fail to meet these requirements will not be permitted to board their flight. Thank you for your time. That's the end of my immigration update. I will now pass it on to my colleague, Michelle, who will give an update on health and safety.
Hello everyone, yes, as Malin said, my session is all about the health and safety cases that have come out of the last year or so. So just a brief overview first on what I'm going to cover in this particular session. Firstly, I'm going to look at a case where the court had to consider who is a PCBU, which in health and safety talk means person in control of a business or undertaking. Secondly, I'm going to look at a case where the question of reparation awards was looked at. Thirdly, I'll look at two cases where recklessness was considered. And finally, a very brief recap on where the Fukari White Island prosecution is at the moment. So just turning to the first case, this is the one where there was consideration of the question of who is the person in control of a business or undertaking. This case was all about a construction accident which happened in Auckland. Essentially what was happening was there was a demolition of a residential home, and during the process of that demolition, unfortunately, one of the walls of the building fell onto the neighbour's building, and in the process trapped someone in the neighbouring property. WorkSafe conducted an investigation, and it decided that it would charge two parties. Firstly, the company who was conducting the demolition, and secondly, a company called Dong SH Auckland Limited, which WorkSafe said were supervising or managing the demolition company. At the district court, Dong SH argued that it wasn't a PCBU because there wasn't any contract between it and the demolition company. And the district court judge agreed with that argument and found that there hadn't been a contractual relationship between the two parties, and that meant that they weren't a PCBU. Being satisfied that they weren't a PCBU meant that the prosecution brought by WorkSafe against Dong SH had to fail because that was one of the elements they needed to prove to make out the charge. WorkSafe took an appeal against that decision, arguing that the interpretation of what was needed to be a PCBU was too narrow. And the High Court agreed with WorkSafe and came to the conclusion that what really mattered was whether, in this case, Dong SH was managing or supervising the demolition, not why or how it came about to be allegedly doing so. So the court will look at all of the facts and make a determination on whether it is a PCBU. It will always help, of course, if there is a contractual relationship, but there doesn't have to be one to be a PCBU. Therefore, the High Court sent the case back to the District Court for a full hearing. The next case I'd like to talk about relates to reparation awards. When prosecutions are brought by any of the prosecution authorities, so that might be WorkSafe, it could be the Civil Aviation Authority or Maritime Safety. And if there's a conviction entered, very commonly a reparation award will be made by the court. That's really the first part of the sentencing process that they will undertake. So this was a case which was a prosecution against Ocean Fisheries Limited, a company that was in the fishing business. Very unfortunately, 3 crew members died as a result of drowning when they were on a fishing trawler. And so Maritime New Zealand took a case against Ocean Fisheries. Ocean Fisheries did plead guilty to the charge, but they had been ordered to pay $505,000 in reparation. And they took an appeal against that reparation order. The reparation order was made to try to compensate for emotional harm that had been caused to the victims of the offending. And in this case, the victims were 3 families of the 3 different crew members who had died on the vessel. What the district court judge had done is had ordered separate payments to be made by 19 different members of the families that were involved. And the appeal was brought on the basis that the judge should have made an order to each of the 3 separate families, not to the specific members of those families. The company also did appeal on other bases also. However, the High Court dismissed that appeal, and they said it was entirely over to the judge to make reparation awards to individual members of the families. They didn't have to be to the families as a whole. In addition, the High Court highlighted how important it was to have data or information on previous reparation awards that had been made for workplace health and safety accidents, and, in the case of deaths, those involving deaths of victims. That very much informs the court's decision on what reparation award should be made in any given case. And the court highlighted the difficulty of trying to quantify emotional harm that had been caused as a result of such accidents. The next case I'd like to talk about, and the next slide, is the first of the recklessness cases that was brought by one of the prosecuting authorities, in this case, Civil Aviation Authority. It is much more difficult to prosecute a party on the basis of recklessness, simply because you have to prove, if you like, a mental state that was in the mind of the defendant. Whereas usually for workplace health and safety, there just has to be proof of a breach of duty, which is more straightforward for the prosecuting authority. In the case of Sgtson, there had been a helicopter accident where tragically a passenger died. Now, the pilot was taking himself and the passenger to a work site, and partway through that journey, the helicopter crashed. The pilot did survive, but he was the one who was later prosecuted. He was prosecuted as being reckless, as well as an alternative charge had been brought against him too. And in deciding whether or not he was reckless, the court applied a certain level of proof, essentially, that needed to be made out by the prosecuting authority. The district court decided it had been proven, and on appeal, the High Court agreed. And what the High Court said is that the prosecution authority needs to be able to prove that the defendant was conscious of the appreciation of the risk, so they knew that they were taking a risk. And then the court will look at, objectively, were the actions reasonable in light of that knowledge? So the High Court did uphold the conviction and dismissed the appeal in that case. The second recklessness case wasn't so successful, and this was a case brought by WorkSafe against Waste Management Limited. Again, sadly, this was a fatality where the worker had died after inhaling hydrogen sulfate gas at work. Now, the company was prosecuted rather than an individual, which was the case for Mr. Sgtson. So the district court approach was to hear from the employees of Waste Management Limited and really decide whether any of them had been reckless. And if they had been reckless, then the company would in turn be found to be guilty of this recklessness charge. However, in this case, the court considered all of the evidence which had been called by the prosecution and included calling all of these workers as witnesses, and decided that that recklessness hadn't been made out in relation to any one of those workers. So while the company had already pleaded guilty in relation to the general breach of duty charge, the court dismissed the recklessness charge that had been brought against it. And the court did highlight the difficulty in providing and producing evidence to prove recklessness. So finally, on to the next slide here, the Fukari White Island prosecution update. So as you'll all recall, I'm sure, the accident at Fukari White Island, or the eruption, occurred in December 2019. Ultimately, 22 people died as a result of that eruption, and additionally 25 suffered injuries, many of them very serious injuries. A detailed investigation was, of course, undertaken by WorkSafe as a result, and ultimately WorkSafe decided to charge 13 parties, 3 individuals and 10 organisations, which was a mix of public and private sector organisations. They were all charged for breaches of the Health and Safety at Work Act. All of the defendants have pleaded not guilty, and it's estimated to be the largest workplace safety prosecution in New Zealand history. There's a trial scheduled for July 2023, which is a long way out, but they needed to find 4 months worth of court time to hold this very lengthy trial. In February 2022, so that's next year, it will be decided whether the trial will take place in Whakatane, the location nearest Fukari, White Island, or in another court. So that'll be an important decision for the people of Whakatane. So no doubt will be updated through the media as this progresses. But for the meantime, I want to thank you for your time tonight and to hand back to Laura Chapman for a few final words.
Thanks very much, Michelle, and thanks everyone for listening and attending this evening. We've got quite a few questions, and I'm not going to get through all of them this evening. So as I say, if you do want to leave your details, we can try and get through offline. Most of them seem to be, not surprisingly, in relation to putting in place vaccine mandates. So I'll get through a few of the questions I can in the next couple of minutes. So one of them was, can employers collect vaccination status from their employees along with their vaccination certificates for planning a return to work in the near future? And I think the answer to that is at a very, very high level, yes. There are some things to think about. And as I mentioned earlier, you do have to be careful about the purpose for which you're collecting the information because you can only use it for a purpose for which you've told your employees you're collecting it. And there has to be a good reason to collect it. So it has to be necessary. So the first two things to ask yourself is it necessary for me to have that information? And it may well be because you're undertaking a risk assessment as to how you're going to plan your return to work. And two, what purpose am I collecting it for? And then three, how will I store that information securely? Because again, it is sensitive personal data. And so I think those things need to be carefully considered when you are actually collecting that data. Another good question that we got is, do we recommend firms engage a health and safety specialist or expert to assist with preparing your risk assessments? That is something that WorkSafe has said for employers to consider doing in relation to vaccination requirements. We've seen quite a big range, and it does depend on your internal capability and what you're used to in terms of risk assessments. I think it's safe to say that prior to 2020, none of us were really expert in pandemics and the risks posed by illnesses related to COVID-19. But what WorkSafe does say in relation to this is, look, we all accept we're not experts, but we can follow the rules of a risk assessment and understand that. And provided to date you have done that adequately, WorkSafe itself is not likely to intervene. Where you could come into difficulty is it's a very, very, as you may know, emotive topic with some employees. And they are likely to try and challenge that risk assessment, kind of one of the areas that that we've seen being challenged in relation to mandates. So I think to the extent you don't feel like you've got internal capability to do that, and you want to make sure you have a robust process, then it can be a good idea to have an external health and safety advisor. What I would say is do be careful about the health and safety advisors that you do engage. There's a lot of people out there now, I think, in that space, and it's just important to make sure they have the right background potentially for your industry and what you're looking at doing. Another great question I thought I would touch on briefly is with the government health website now stating a vaccinated person may infect another person without knowing because they have no symptoms, how will that impact on the assessments? That is something that comes up often. So don't forget that what you're looking at from a workplace health and safety perspective is there a risk to your employees? And if so, you're looking to minimize that risk so far as it's reasonably practicable. Now, the risk to your employees isn't necessarily transmission of COVID or even contracting COVID in some circumstances. It might be that the risk you're trying to prevent is the severe consequences of COVID. So things like severe illness, hospitalization and death that we know unfortunately can be associated with COVID. And so whilst transmission is a relevant factor, it's not the only factor that you are thinking about in relation to your risk assessment. And in fact, that's very much a public health issue because we're talking about, when we're looking in the public health sphere, we're talking about trying to limit it so that we don't overwhelm our healthcare systems, as opposed to looking at it from a workplace health and safety perspective when we're looking at trying to protect individuals and how we do that. And now what we're saying in relation to a vaccine often is, or what employers are saying is, we think that is an effective and reasonably practical measure to take to minimise the risk to our employees of, for example, serious consequences of COVID. So I think first it depends on what you are trying to prevent in your workplace. In some workplaces, particularly those covered by the mandate, there is that issue of preventing transmission. Other workplaces, it's not necessarily transmission, but those more serious effects that we're trying to prevent. And I think there are a lot of other great questions on there. We will try and answer them, as I say, if you leave the details, but otherwise I wanted to thank everybody for spending your evening with us. Hopefully it's been informative as to the 2021 year in review. And please do join us again next week for another set of our colleagues who will be presenting the part 2 of this series to you. So thank you very much, everybody.